never know. Man, things should be easy, but people want to make them so difficult. Childbirth should be a joyous time. You know what I mean? It's supposed to be a joyous time. But here we are, learning a lesson. A lesson about what happens when you jump into these stargates. We're gonna call them stargates. Wombs. You know what I mean? When you impregnate these women without looking down the road. Right? And third parties is set to get involved. So you gotta go and see what the law says about your rights. So in doing that, I'm looking at the Child Welfare Information Gateway, PDF, called The Rights of Unmarried Fathers. Right? So let's go. Over the past several decades, unmarried fathers have challenged the termination of their parental rights under the 14th Amendment in cases in which birth mothers relinquished their children for adoption. Alright? Under the 14th Amendment. See, that's not going to work. But for the sake of those who don't understand that they're Moorish Americans, Moorish Al-Moroccans, you know what I mean? And that the Constitution is for the United States, then you'll be assuming that you fall up under the 14th Amendment. So first, we probably should just state that the United States is a corporation with several departments. It's a business, right? So you have to understand that this is a business trying to assert business rules or business laws over you, living souls. Man and woman. Right? If you don't understand you're a living soul, I don't know what to say. Except maybe to give some degrees on what a living soul is. You. What is soul? Where does soul come from? Let's take a look. Let's look at the etymology of soul on my favorite site, Etym Online. Alright. Soul. Noun 1. A substantial entity. Substantial. Substance. You know what I mean? Sub is always that which is beneath. It is a substantial entity believed to be believed to be that in each person which lives, feels, thinks, and wills. And they commandeered all these words, you know what I mean, and flipped them into legalese, but we'll get into that another time. That's from the Central Century Dictionary. It's from Old English sawol. Sawol, right? Spiritual and emotional part of a person. The spiritual and energy in motion part of a person. Animate existence, life, living being. That's from Proto Germanic. Sawalo. Sawalo. Source also of Old Saxon Sheola. Old Norse Sala. Old Frisian Selle. Middle Dutch Seal. Dutch Zeal. Old High German Seula. German Seal. Gothic Shaiwala. Of uncertain origin. They gave you all those, but those words were uncertain of the origin to those people, right? Sometimes said to mean originally coming from or belonging to the sea. Like sea salt. Because that was supposed to be the stopping place of the soul before birth or after birth. About that. You went into the water, right? And then came out of the water into a different density of water and left the afterbirth. If so, it would be Proto-Germanic Saiwas. See. Klein explains this as from the lake, right? As a dwelling place of souls in ancient northern Europe, that's Europe, meaning, quote, spirit of a deceased person, is attested in Old English from 971 as a synonym for person, individual, human being, as in every living soul. It dates from early 14th century. Soul searching, noun, is attested from 1871 from the phrase used as a present participle adjective 1610s. Distinguishing soul from spirit is a matter best left to who? Theologians. So, soul, the etymology, you know what I mean, comes from all those different European languages, but they had no idea of its origin. Soul, right? And then you see the tie-in with the sea, right? Because it's still dealing with water. Different densities of water. Moving through different densities of water. Roundabout a way to get to reading this PDF. But it's things that need to be understood. Then they got for soul noun 2. Check this out. The quote, instinctive quality felt by black persons as an attribute, end quote. 1946 jazz slang from soul, noun 1, which we just read. Also from this sense are soul brother, 1957, soul sister, 10 years later, 1967, soul food came before soul sister, 1957, even though it was probably the soul sister cooking the soul food in 1957. etc. Soul music, essentially gospel music with girl in place of Jesus. First attested 1961. Wait a minute. Soul music, essentially gospel music with quote unquote girl, etc. in place of Jesus. First attested 1961. William James used the term in 1900 in a spiritual slash romantic sense, but in reference to inner music. That inner music makes sense in dealing with the soul. You know what I mean? Which is the living energy of the sun, because let's see, what is that? How far do we go back? 971. Let's go with Saul. Saul, noun, the sun personified. Soul. See, there's the same Sewell, Sawel, right? Mid 15th century. From Latin sol, the sun, sunlight. From Proto Indo European, Sewell, variant root of Sawel. Sawel, you saw well. The sun, French soleil, 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 is from Vulgar Latin soliculus, diminutive of sol. In Vulgar Latin, diminutives had the full meaning of their principal words. Right? So, soul had the full meaning of soliculus. Then you have soul as a prefix, meaning whole, well kept. And you see the words that it forms. All or part of Catholic consolidation, holism, hollow, holocaust, holocene, hologram, holograph, insouciant, safe, safety, sage, salubrious, salutary, salute, salvage, salvific, salvo, save, save as a preposition, accept, soldier, soldier, solemn, solicit, solicitous, solid, solidarity, solidity, soul, right? Soul, responsible for good health and well-being, right? That's why the sound we emit as soul music makes you feel whole and well kept, safe, and all those other words that have the root soul in them. Right? So you're a living soul. Right? A sologram. Right? There's that soul. But then we gotta go to where they get this stuff from, because he said you gotta ask the theologians. Theologians go back to the Biblos. Right? We're gonna look up soul. Soul. What does the Strongs call the soul? Nefesh. Nefesh. A soul, living being, life, self, person, desire, passion, anger, appetite, emotion, all those things. They use the word nefesh. And where is it seen? Genesis 1:20. Right? And that is used of creatures, right? Creatures, right? So all things had the nefesh, but let's look at another word real quick. Let's see what they say for spirit. See? This is where we get down to the meat and potatoes because this is the current. Ruach. Breath, wind, spirit. Right? Strong 7307 reduces to 8. Yeah, I mean, that show the intertwining energy. Right? But you got the ruach, the breath, the wind, the spirit. That is the soul. When do we see it first? Genesis 1:2. When it speaks of the spirit of the Elohim. Right? So, you gotta understand, you are the Ruach, the living being. And because all they stuff comes from here. The Bible. And the Bible says that you are born living souls. Called the breath of life. It is the vital energy, the current, that which is breathed in all these different densities. Right? So let's get back to it. Alright. In a series of cases involving unmarried fathers, the U.S. Supreme Court affirmed the constitutional protection of such a father's parental rights when he has established a substantial relationship with his child. The court found that the existence of a biological link between a child and an unmarried father gives the father the opportunity to establish a substantial relationship, which it defined as the father's commitment to the responsibilities of parenthood as demonstrated by being involved or attempting to be involved in the child's upbringing. We'll have to find that case law. Alright. For this publication, the laws for making determinations of parentage were collected for all states, the District of Columbia, and the U.S. territories, and an analysis of this information informs the discussion that follows. Right? Notice that it states lowercase states definition of father. While there is no standard definition of quote unquote father in statutes across the states, there are a number of terms that describe the status of a parent-child relationship between a man and his child. Alright? Let's go back. While there is no standard definition of father in statutes across the states, there are a number of terms that describe the status of a parent-child relationship between a man and his child. The term quote unquote legal father generally refers to a man married to the mother at the time of conception or birth of their child, or whose paternity has been otherwise determined by a court of competent jurisdiction. Alright? When the parents of a child are not married to one another, states use an array of terms to describe the status of a man who may be the biological father. These terms include the following. A quote unquote putative father is a man who is the alleged biological father of a child, but whose paternity has not been legally established. Then there is an alleged father, is a man who alleges himself to be or is alleged to be the genetic father or a possible genetic father of a child, but whose paternity has not been determined. Then you have in the next column over here, an acknowledged father is a man who has established a father-child relationship by signing an acknowledgement of paternity. Then you have an adjudicated father is a man who has been adjudicated by a court of competent jurisdiction to be the father of a child. Then you have a presumed father is a man who is recognized as the father of a child until that status is rebutted or confirmed in a judicial proceeding. In approximately 27 states, the District of Columbia, American Samoa, and the Northern Mariana Islands, a man may be presumed to be the father of a child in any of the following circumstances: he and the child's mother are or were married to each other, and the child is born during the marriage or within 300 days after the marriage ended. Before the birth of the child, he and the child's mother attempted to marry, and the marriage is or could be annulled, and the child is born during the marriage or within 300 days after the marriage is terminated. Keep in mind that marriages, they talking about state sanctioned marriages. He has acknowledged his paternity in writing, affidavit time, right? He is obligated to support the child either by voluntary agreement or court order, affidavit time. While the child is a minor, he has resided with the child and openly claimed the child as his biological child. Affidavit time. Let's see. That case law was Stanley versus Illinois, 405 U.S. 645, 1972. Quilloin versus Walcott, 434 U.S. 246, 1978. Caban versus Muhammad, 441 U.S. 380, 1979. Lair versus Robertson. Right, that's the case law down there. We'll look that up as well. You know what I mean? Then the fourth one, the word approximately, is used to stress the fact that states frequently amend their laws. This information is current through August 2017. Alright. Alabama, Arizona, Arkansas, California, Colorado, Delaware, Hawaii, Idaho, Kansas, Maine, Massachusetts, Minnesota, Missouri, Montana, Nevada, New Jersey, New Mexico, North Dakota, Ohio, Oregon, Rhode Island, South Carolina, Tennessee, Texas, Virginia, Washington, and Wisconsin use one or more of the elements listed to define a presumed father. Dun, 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 dun. Alright. Paternity registries. Dun-dun. Before a man can assert any rights with regard to the care of a non-marital child, he must first establish his paternity of the child. Many states have provisions for a father to voluntarily acknowledge paternity or the possibility of paternity of a child born outside of marriage and record the fact in a putative father registry. What does putative mean? Because when you got that pew in front of shit, it's like punitive. So putative. Putative. Adjective. Supposed, reputed, commonly thought of, or deemed. From early 15th century. From late Latin putativus, supposed, from putat, past participle stem of Latin putari, to judge, suppose, believe. And I would have just gave you the $3, but that's cool.
Okay, well, I haven't got processed it yet, but I was like, that's fine. I'll add pineapple to it. It comes with the vegetables, and I'll add pineapple to it. Okay.
Alright, so putative, supposed. You know what I mean? Alright. So, putative father registry. Approximately 25 states have established registries for this purpose. In 22 states, the District of Columbia, and the Virgin Islands, there are provisions for voluntary acknowledgement of paternity through forms that are filed with social services departments, registrars of vital statistics, or other similar entities. Acknowledgement of paternity or registration with a putative father registry ensures certain rights for an unmarried father, such as the right to receive notice of court proceedings regarding the child, petitions for adoption, and actions to terminate parental rights. In 11 states with putative father registries, filing with the registry is the primary means for establishing this right of notice. An acknowledged father also may seek visitation with the child and usually will be required to provide financial support to the child. Financial support. Alternative means of establishing paternity. In 21 states, Guam, and the Northern Mariana Islands, a person may claim paternity to a child by filing an acknowledgement or affidavit of paternity with the court. Right? In 26 states, American Samoa, and the Northern Mariana Islands, a man may consent to the placement of his name as father on a child's certificate of birth as a means. Let's see, 7. Here's Virginia. Right? Of course. In 11 states with putative father registries, filing with the registry is the primary means for establishing this right of notice. That's in Virginia. Alright? Eight is also Virginia. You can claim paternity to a child by filing an acknowledgement or affidavit of paternity with a court. Let's look up examples of an affidavit of paternity. Be an example right here. And presently residing have been duly sworn to in accordance with law. Do hereby depose and say that I am the biological father of. Alright, so There are the points to be addressed so that you know that an affidavit stands as true, has to be rebutted, right? And that's how we got to start looking at this stuff. We got to come the other way with it, right? So now, coming in the other column, a man may consent to the placement of his name as father on a child's certificate of birth as a means of asserting his paternity, asserting a man, the child's mother, or other interested persons also may petition the court to establish a man's paternity. The court, after weighing all available evidence, will make a determination of the child's paternity. In 41 states, the District of Columbia, and the Virgin Islands, a court may order the alleged father, the child, the child's mother, and any other man making a claim of paternity submit to blood and other genetic tests as a means of determining the biological parentage of a child. When the results of genetic tests reveal that there is a high statistical probability that a man is the biological father of a child, the court will make a judgment of paternity. In 15 states, a man can be declared not to be a child's father, or a prior judgment of paternity may be nullified when genetic tests exclude the man as the child's biological father. Right? Required information. States differ in the information they require for registration or acknowledgement of paternity. The information that is needed to complete the registration typically includes the following: the full name, date of birth, and address of each parent, the full name, date of birth, and residence of the child, a signed witness statement by the birth mother consenting to the acknowledgement of paternity, a signed witness statement by the birth father acknowledging his paternity. This is the required information. Right? The signatures of the mother of the child and the biological father, the date the registration or acknowledgement was completed. In many states, the acknowledgement of paternity form also will provide essential information to the registrants, including the following: a statement of rights and responsibilities, including any rights afforded to a minor parent, a statement of the alternatives to and consequences of signing the acknowledgement, information concerning the legal implications of completing the form, including the procedure for establishing parentage, parental rights and responsibilities, and child support obligations, a statement that the man who signs the form is acknowledging that he is the biological father of the child named in the form, and that he assumes the parental duty of support of that child. And like I said again, with these words, they have hijacked them because duty has a different meaning in legalese. Let's see if we can pull up the free dictionary. And we gonna go to the legal dictionary, and we're gonna search for duty. Duty, a legal obligation that entails mandatory conduct or performance. With respect to the laws relating to customs duties, a tax owed to the government for the import or export of goods. And that is what they mean by duties, the tax that they want to get from what they call importing or exporting the goods, which is our children. A fiduciary, such as an executor or trustee, who occupies a position of confidence in relation to a third person, owes such person a duty to render services, provide care, or perform certain acts on his or her behalf. In the context of negligence cases, a person has a duty to comport himself or herself in a particular manner with respect to another person. Duty, a legal obligation, the breach of which can result in liability, right? Which is what they try to stick you with. In a lawsuit, a plaintiff must claim and prove that there was a duty by defendant to plaintiff. This can be a duty of care in a negligence case or a duty to perform in a contract case. And that's what they're trying to do, contract. Anytime lawyers and shit like that get involved, they're trying to enter into a contract with the state so that they can have jurisdiction, so that they can impose duties on you, the living soul. Alright? So there are things that you got to be aware of. Alright? So, in many states, the acknowledgement of paternity form also will provide essential information to the registrants, including the following. And that's what we got to parental duty of support of that to a child. A tax on the support, right? Because they're going to try to claim they're giving you a loan. Or the woman will go in there and try to take out a loan. You know what I mean? And have you co-sign it. Revocation of claim. Approximately 48 states, the District of Columbia, and the Virgin Islands make provisions in their statutes that allow putative fathers to revoke or rescind a notice of intent to claim paternity. Of these states, approximately 11 allow revocation at any time. Revocation is effective only after the child's birth in Arkansas and Iowa. In Florida, a registration that is submitted prior to a child's birth may be withdrawn only prior to the child's birth. Approximately 31 states, the District of Columbia, and the Virgin Islands limit the right of rescission to 60 days after the paternity claims is submitted or prior to a court proceeding to establish paternity, whichever occurs first. In 25 states and the Virgin Islands, a claim of paternity may not be revoked after the 60-day period except by court action on the basis of fraud, duress, or material mistake of fact. Right? Access to registry records. Access to information maintained in paternity registries also varies from state to state. Many jurisdictions permit certain persons access to registry records. In general, these are people with a direct interest in a case. Typically, persons entitled to access include birth mothers, courts, attorneys, licensed adoption agencies, prospective adoptive parents, state departments of social services, state offices of child support enforcement, registries of states, or any other person upon a court order for good cause. What don't you see in that? You don't see father. Access to registry records. Certain persons, in general, people with direct interest in a case. See, that's all legalese. Persons, cases, interest. Typically, persons entitled to access include, this is typical, and typically you don't see father. Right? And there are some things that can be looked at. Citations. And then this is all about for more information. Alright? But you get the gist. Don't allow yourself to be classified as a person. You know what I mean? You are a man. You are a father. You can write an affidavit, because an affidavit stands as truth. Check it out. What is the legal definition of an affidavit? Affidavit, a written statement of facts voluntarily made by an affiant under an oath or affirmation administered by a person authorized to do so by law. An affidavit is voluntary, made without any cross-examination of the affiant, and therefore is not the same as a deposition. A record of an examination of a witness or a party made either voluntarily or pursuant to a subpoena, as if the party were testifying in court under cross-examination. A pleading, a request to a court to exercise its judicial power in favor of a party that contains allegations or conclusions of facts that are not necessarily verified, differs from an affidavit which states facts under oath. Affidavit is based upon either the personal knowledge of the affiant or his or her information and belief. Personal knowledge is the recognition of particular facts by either direct observation or experience. Information and belief is what the affiant feels he or she can state as true, although not based on first-hand knowledge. Any public officer authorized by law to administer oaths and affirmations, such as city recorders, court clerks, notaries, county clerks, commissioners of deeds, and court commissioners, may take affidavits. Justices of the peace and magistrates are sometimes authorized to take affidavits, unless restricted by state laws. Judges may take affidavits involving controversies before them. Alright, so affidavits. In judicial proceedings, affidavits serve as evidence in civil actions and criminal prosecutions in certain instances. They are considered a very weak type of evidence because they are not taken in court, and the affiant is not subject to cross-examination. Their use is usually restricted to times when no better evidence can be offered. If a witness who has made an affidavit is not available to testify at a trial, his or her affidavit may be admitted as evidence. If the witness is present, his or her affidavit is inadmissible, except when used to impeach the witness's testimony or to help the witness with past recollection of facts. Right? So affidavits. Right? Like I said, this is the rights of unmarried fathers. You know what I mean? For living souls, men, you know what I mean, who have made the mistake of getting a woman pregnant, and you know what I mean, from the gate they're trying to determine what your rights are. So you need to preempt that. Right? So that's what we're going to get to. Creating an affidavit. And on that note, it's Kevin L. I'm going to get up out of here. You know what I mean? You can see the web address for it right here if you want to go check it out for yourself. You know what I mean? And I'll be back, you know what I mean, with more information. Willing myself to be more consistent with giving out information that's needed and necessary. So, peace, blessings.